Good evening, everyone. My name is David Lauder. I'm one of the advisors here at the DDU, and I'm going to be speaking to you this evening about obtaining consent. Before I forget, if you have any questions about the presentation, we'd be grateful if you could put them into the questions box through the webinar, and I'll get to as many of them as I can at the end. Also, with regard to your certificates, you'll be issued with a certificate once you've completed the feedback form, which you'll be sent at the end of the presentation. So just very briefly about me, I'm a dentist. I qualified in Newcastle in 2002. I worked in general practice in the UK and Australia. I did some restorative training, some dental implant training. I joined the DDU as a full-time advisor in 2015, and I've got a master's in medical law. So we're going to be talking to you this evening about consent and how the law of consent has evolved over the years, both through the lens of the courts, but also how that relates to the GDC standards. And we're also going to be discussing how consent is obtained and how it is best demonstrated, particularly through your clinical records. And it's anticipated that the presentation this evening will relate to GDC development outcomes A and D. So these are the subjects we're going to cover. We're going to talk about what consent is. We'll talk about capacity. We'll talk about how the law on consent has evolved, and what that means is specifically in relation to claims for compensation and the courts. And we'll also talk about how that relates to GDC guidance, and then we'll give you some practical tips about consent, and again demonstrating how best to demonstrate that it's been obtained. So what is consent? Consent is the expressed or implied permission of a patient to undergo a dental examination, investigation, or treatment. It can either be implied or expressed. You guys might have heard the term implied consent before, and the image of implied consent in relation to dental treatment would be a patient sitting back in the dental chair with their mouth open. And I think that you can take implied consent to proceed with an examination, but that's probably as far as you could take it. And for anything else, you would need expressed consent. And of course, that can be verbal. If it's verbal, is it recorded, not recorded? Is it written? Is it informed, fully informed, valid? You might have seen some of these terms before. Arguably, this terminology could be considered sort of jargon, really, dental legal jargon. Particularly when you think to yourself that the patient is pretty unlikely to be using these kind of terms. And this is arguably an example of how consent can be overcomplicated. The patient's not going to be describing whether or not their consent was informed, fully informed, or valid. They're simply going to be saying whether or not I gave consent to proceed. And really, that's the question that we should be asking ourselves. Have we got the patient's consent to proceed, and not overthinking it with this kind of terminology? I think that's an important thing to think about. But of course, it's a fundamental principle of good practice. Any investigation carried out without consent could be regarded as battery. I have to say that that's vanishingly rare for that to happen. I've certainly never come across it in my time at the DDU for criminal proceedings to come out, of the other side of an issue relating to consent. But it is a common part of claims for compensation these days, and it's certainly a common allegation that the GDC can make when through fitness to practice proceedings, an allegation that there's been a shortcoming in the consent process. So claims for compensation, GDC investigations, it's certainly something that comes up. Criminal proceedings, incredibly rare. But it is very important, as Lord Justice Lawson's quote demonstrates. Just to reassure everyone, these kind of headlines again are incredibly rare, because the reality is that consent isn't normally a problem. Dental professionals are treating their patients successfully day in, day out. In the vast majority of cases, there's no issues with consent. So again, these kind of headlines shouldn't scare or spook people. But this is obviously just an example of what can happen if things do go wrong. And it's interesting because these headlines specifically relate to sort of cosmetic type treatments, and it's worth remembering that And in relation to having a discussion with a patient about cosmetic treatments, let's say, for example, porcelain veneers or veneers of some kind, we as dental professionals might think to ourselves, well, what are the risks of those treatments? Well, the porcelain veneers could fracture, they could debond. And let's say from our perspective as dental professionals, if that doesn't happen, and let's say after 10, 12, 15 years, those veneers are still on, and they haven't chipped, they haven't fractured, we could consider that treatment pretty successful. But the word that was used to me recently in relation to this was, well, actually, it's not just the risks in that sense, but also what are the consequences of that treatment. And in relation to porcelain veneers, for example, even if that treatment from our perspective has been successful after 10, 12, 15 years, what are the consequences to that patient when those veneers inevitably need replaced? Is it going to be crowns? What's going to happen to the pulps inside those teeth? And it's those kind of longer term consequences that even if something dramatic hasn't necessarily happened along the way, that when they inevitably transpire down the line, that patient could look back and say, well, if those consequences had been explained to me at the beginning, I wouldn't have gone ahead, and therefore I didn't give consent for this treatment. So it's worth remembering that it's not just the sort of dramatic risks that we need to be discussing with patients, but it's also the consequences, the inevitable consequences, as that dental treatment inevitably needs replaced down the line. So it's very important to manage patients' expectations, not promising treatment that's not achievable, not promising a time scale that's not achievable, building contingency plans into our treatment plans, and of course, keeping patients informed. And we could all think of different examples of dental treatment plans where this kind of thing is relevant. And in relation to timescales, we've all had patients who want their denture fitted or their crowns fitted or their treatment completed by, let's say, Christmas or their daughter's wedding or whatever it is. And it will inevitably be sod's law that for that particular patient, that lab work will be delayed, or that denture will need more than one try-in. And if we've anticipated those potential complications and built in contingency plans, or at the very least warned the patient of that possibility, then we're if and when they do happen, we're less likely to get a problem. So what's capacity? So the three principles of consent is that the three things that need to be in place are the patient needs to be competent, the consent needs to be voluntary, and the patient needs to have been given sufficient information to make that decision. So what information should be provided? The nature and purpose of the proposed treatment, risks and benefit, reasonable alternative treatment options, we'll come on to that later. The costs obviously associated with each treatment option, and the potential consequences if no treatment is provided. So voluntariness, consent is only valid if it's been obtained without undue coercion or manipulation. So the patient shouldn't feel as though they're under any pressure to go ahead. And of course, they might feel that they're under pressure or they're being coerced, where it might be entirely unintentional from our perspective. So things to think about is giving patients what's called a cooling off period before you actually start the treatment. And obviously, the obvious example of that could be at an examination appointment, at a consultation, patient is, options are discussed, patient's given information about those options, they then are allowed to go away and think about them and come back for a further appointment at which they're given an opportunity to ask questions. And certainly asking the patients if they have any questions, documenting that you've done so in the notes can be very helpful when it comes to defending concerns or allegations when it comes to the consent process, because it helps demonstrate that you've tailored the consent process to that individual patient, which is a key thing to do. So a patient's competent if they have the capacity to understand the information, make a judgment about it, and to communicate it. When we think about competence and capacity, we can either think about very young patients or perhaps more elderly patients, but it might simply be that a patient's nervous. If they're nervous, are they actually taking the information in? Does the patient understand the information? Is it enough simply for the patient to nod? Are we confident that the patient actually understands the information? And are they able to retain it? And obviously, the obvious example is perhaps more elderly patients who might have difficulties doing so. So who can give consent? The bottom line is only the patient can truly consent. And this applies to children, adults, and people with disabilities. Can parents consent? Grandparents, foster parents? The reality is that only parents have legal parental responsibility. All mothers have automatically have parental responsibility. Parental responsibility rests with both parents, provided they're named on the birth certificate, and regardless of whether or not they are married. But the reality is that parental disputes, and these can come in various, shapes and sizes, in the form of complaints and, disputing parents requesting copies of clinical records, in the context of a dispute to establish what happened and when, and who's been bringing appointments when, can be a very contentious area. And so my advice would be, if you're ever faced with a situation like this, either through the context of a complaint or a request for records, get advice from us, because they can be tricky and very sensitive areas. You guys will probably have heard of the term Gillick competence. So the legal age of consent is 16 and 18. It's 18 in Northern Ireland. And of course, the question then is that a patient under the age of 16 can still be mature enough to give their consent if you've assessed them as that being the case. Are they able to understand, retain, weigh up the necessary information to communicate their decision? And when it comes to dental treatment, it's wise and usually not a problem to be involving parents too, even if you do think that that 14, 15-year-old is mature enough to give consent themselves. It would be a good idea to involve the parents, to include them in that, make them aware of that, of what's happening, to avoid, complaints down the line. If instead you think a patient doesn't have capacity, ultimately we've got to provide treatment which we think is in the patient's best interests. It's a good idea to involve parents, involve carers, family members if possible, and you need to be able to justify your treatment plan. With adults, you need to be able to demonstrate that you've complied with the relevant Mental Capacity Act, which emphasise the importance of partnership in decision making, good communication, respect for the patient's own values. And remember, of course, that capacity to consent varies and depends on different factors, including time. Some elderly patients and their capacity to consent may differ from one day to the next. It may also vary depending on the complexity of the procedure. They may be able to provide their consent to, have capacity to consent to, a crown fit, perhaps, but not a full mouth rehabilitation. And again, seeking, and one of the things that's worth considering in a situation like this is asking for an independent second opinion from another dental professional. So involving others, this idea of sort of shared decision making is a good idea, and obviously documenting in the records that you've done so. And again, trying to involve those others involved in the patient's care, family members, carers, perhaps other medical professionals too, so that again, you can demonstrate that you've approached this in the right way. But ultimately, the way that you assess capacity, both for very young patients or elderly patients or anyone else, is to assess whether or not they understand the information necessary. Are they able to retain that information? Are they able to weigh it up as part of the process? And can they communicate their decision by any means available? Accepting, of course, that different patients communicate in different ways. And again, this comes back to us being able to demonstrate that we've tailored the consent process to that individual patient, because they might communicate in different ways. They might want and need that information to be presented to them in different ways, but for whatever reason. And we're willing and able to do that. So can you decide what's in the best interest of the patient? Interestingly, there's no definition of what best interests means in the Mental Capacity Act. However, there should only be one course of action that's in a patient's best interest. And of course, it's not limited to their best dental interest. We might think that, you know, an implant retained bridge might be the best dental solution to a particular patient's problem, but of course that might not fit in with their overall well-being and their social, emotion, psychological and other interests. And of course we've got to take all of those factors into account in order to decide what we think is actually in that individual patient's best interest. It's not just about what's best from a dental perspective. And of course, the most important thing is that you need to keep a good record of how this decision was reached, bearing in mind, of course, that, you know, those records may never, you know, need to be scrutinized, but if they are, it might be for a long time down the line when what was in your mind at that point is no longer fresh. So you want your clinical records to demonstrate very clearly, essentially, what your thought process was, how that decision was reached. What were the reasons and factors that you considered? Who was consulted? When we talk about second opinions from other dental professionals, family members, carers, other medical professionals, what particular factors were taken into account? And of course, that needs to be recorded very clearly in the patient's notes. So how has the law on consent evolved? And again, this is specifically through the lens of claims for compensation. Interestingly, the Hippocratic Oath doesn't mention anything about consent, asking what patients want, explaining the consequences, or consulting them about their wishes. And it wasn't until the 20th century, really, that the principle of patient autonomy, the patient's right to make their own decisions, gradually replaced the older tradition of medical paternalism, that tradition of, you know, the doctor's always right and don't question what they're saying. That slowly but surely was replaced during the 20th century. You'll have probably heard of the Bolam standard, which still applies to clinical negligence claims in general today. And when the judgment was first made in 1957, applied to the consent process too. And what the Bolam standard says is a medical professional is not considered negligent if he, interesting use of a gender-specific word there, arguably illustrating how paternalistic the view of medicine was at the time. If he follows a practice that it's accepted as proper by a reasonable body of medical experts in that field. So as long as you can demonstrate that what you were doing or not doing is in line with a reasonable or responsible body of opinion, then you shouldn't be considered negligent. And again, in 1957, this applied to the consent process. As long as the doctor or dentist, the medical professional, could demonstrate that they had, you know, given information or complied with a consent process that would have been supported by a responsible body of other medical experts. So it was for the medical profession to decide what was reasonable in that context, then you weren't considered negligent. But that slowly started to change. So with Sidaway versus the Board of Governors, House of Lords ruled that medical professionals must, again, disclose the amount of information deemed appropriate by a responsible body for medical opinion. So it supported Bolam. So the majority decision, i.e. the actual judgment, supported Bolam, but one of the judges, a guy called Lord Scarman, in a minority opinion, so it was still part of the judgment, argued that actually it was patients who've got a right to decide whether to proceed with treatment, and doctors have a duty to inform patients about any material risks. So while Sidaway didn't change the law, Lord Scarman's view and opinion made up part of that judgment, so it was actually still there. And by the late 1990s, it was Lord Scarman's view that was gaining popularity and started being adopted by judges in the courts. This coincided with other developments that were relevant, including the Human Rights Act, the right to respect for a private life, the Mental Capacity Act we've talked about already. And at the same time, there were landmark decisions being made in other countries, the USA, Canada, and Australia, that firmly moved the law in these countries towards patient autonomy. So there was a general direction of travel towards patient autonomy. But the law didn't actually change in the UK until 2015, Montgomery versus Lanarkshire. And following this judgment in the Supreme Court, it's now the patient, not the medical professional, who decides how much information should be given for valid consent to be obtained. A patient should be warned of all material risks. And what does that mean? The test for materiality is whether, in the circumstances, a reasonable person in the patient's position or the doc would likely attach significance to the risk, or the doctor is or should reasonably be aware that that particular patient would be likely to attach significance to it. Helpfully, last year there was a further judgment, McCulloch versus Forth Valley Health Board, which clarified that whether an alternative treatment options need to be offered or explained, or the patients need to be made aware of treatment options. The expectation is that you only need to make patients aware of what the doctor or dentist considers to be reasonable treatment options. So this clarified the requirement in relation to what treatment options need to be given, and you can't be required to advise a patient about a treatment option that you don't think is reasonable. And an obvious example of this in relation to dentistry is the patient that comes into your surgery with raging pulpitis, needs treatment, and you're discussing options with them. You're not required to give them the option of no treatment if you don't consider that to be a reasonable option. So once you've decided what treatment options are reasonable, you've got to provide the patients with the information about all of them. And so how does this relate to GDC guidance? You'll all be familiar with the GDC standards. We received a booklet when we all registered with the GDC. Importantly, the GDC standards apply to all dental registrants equally, from dentists, dental nurses, dental technicians, clinical dental technicians. And of the 9 principles, 2 are particularly relevant. The importance of communicating effectively with patients, and principle 3, the requirement to obtain valid consent. So communicating effectively with patients. 2.3, we need to give patients the information they need in a way that they can understand so that they can make informed decisions. You satisfy yourself that patients have understood. If you look closely, you'll start to see the same language that's been used in the Mental Capacity Act, for example, some of the judgments that we've discussed appearing again in the GDC standards. Make sure that patients have enough information and time to ask questions and to make a decision. So it's not only a good idea to give a cooling off period and to ask whether or not patients have any questions, it's also in the GDC standards. You must give patients a written treatment plan. Worth looking out, if you're ever looking at the GDC standards, look how the GDC used the word must and should at different times. And of course, there's more room for maneuver with a should than there is a must. But with 2.3.6, you must give patients a written treatment plan, detailing their costs before treatment starts. Because, of course, how can a patient give consent if they don't know what the treatment's going to cost? And of course, that treatment needs to include the proposed treatment, a realistic indication of the cost, and whether or not it's going to be provided under the NHS or privately. So principle 3, which is in the current GDC standards, replaced the previous GDC guidance on consent, which was issued in 2005, and that was called Principles of Patient Consent. So prior to, I think it's 2013, when the current GDC standards were published, the GDC had separate guidance documents in relation to consent. It was this Principles of Patient Consent 2005. That was then replaced by Principle 3 of the standards. That's relevant in a second. But again, Principle 3 talks about obtaining valid consent before treatment starts. Make sure that patients they understand the decisions they're being asked to make. Make sure that the consent remains valid at each stage of the investigation or treatment. Again, remembering that this is an ongoing process. It's not a fixed mark. Consent is an ongoing process. You should document the discussions that you have with patients in the process of gaining consent. This is important from our perspective in the sense that if we're ever assisting a member and the consent process is being scrutinized or criticized in some way, the best evidence from our perspective that consent has been achieved is a good, bespoke note in the clinical records illustrating that two-way discussion that the members had with that patient. And when I say bespoke, I mean be very careful with auto notes if you're going to record a discussion regarding consent, because if you can imagine, if you're looking at a patient's clinical records and there's exactly the same auto note being used over multiple appointments detailing exactly the same discussion with that patient, it doesn't take much to imagine a clever third party asking what's the likelihood that entry in the notes is accurate. So again, it doesn't have to be massively detailed, but it should be bespoke, and it should illustrate that two-way discussion that we're all having with our patients day in, day out. As we're gaining consent, as I said at the beginning, we're all gaining consent from our patients and we're proceeding, and there's not usually a problem. And again, if that note in the records just simply illustrates that two-way discussion, that's the best way for us to help demonstrate that actually the consent was achieved. Again, make sure that patients have understood. Remember that patients can withdraw their consent at any time. Again, it's not a fixed mark. This is an ongoing thing. And patients certainly have the right to withdraw their consent down the line if they wish. Again, we talked about giving patients a reasonable amount of time in a format they can easily understand. As we've said, that can vary from patient to patient, depending on the circumstances, whether or not that they've been given the information in a format that's good, easily understood by them. And of course, encouraging friends, relatives and carers, family members to be included in that decision. It's not just a requirement of the Mental Capacity Act. Again, it's in the GDC standards. You must always consider whether patients are able to make decisions about their care themselves and avoid making assumptions. And in fairness to the GDC, they do recognize that this is this can be a complex area, and there can be developments and changes, and as a result, you should pick up the phone and speak to an advisor at the DDU. We will, if let's say you're faced with a tricky set of circumstances, you've got doubts about a particular patient's capacity, you're not sure how to proceed, it can be very helpful often to have a discussion with an advisor, and hopefully we'll be able to help you navigate that situation. But of course, good clinical records are very important, and documenting that patients have understood the information you've given them can again be helpful to put in the records. But again, it's a process. It's not a one-off event. It's not a signature on a consent form. It's not a box that needs to be ticked either literally or metaphorically at the beginning of a treatment plan and can then be put in a drawer and forgotten about. It's an ongoing process, and it's worth having those discussions that we're all having with our patients, having ongoing discussions, particularly, of course, if the treatment plan is going to change, but even not, if we're carrying out longer treatment plans with our patients, having those discussions ongoing continuing to give patients an opportunity to ask questions if they have them, documenting that in the notes. All of these kind of things are just good habits to be into and don't necessarily need to take loads of time. You must tailor the way you confirm ongoing consent to each patient's needs and check that patients have understood. So again, tailoring the consent process to that individual patient instead of just doing the same thing for every single patient and just assuming, well, that's the way I get consent from my patients. We need to be alive to the fact that there needs to be a degree of flexibility in how we do things, depending on the circumstances and depending on the patient. But again, documenting the discussions, that's really very, very important. Again, certainly from an evidence of the consent process perspective, is from that perspective, it's key. And again, as you can see, the GDC are using the word must there. So how does Montgomery fit into all of this? So Montgomery, as we've talked about, changed the law in relation to requiring us to. It's about the individual patient. What would a reasonable person in the patient's position, or what would that medical professional reasonably expect the patient to attach significance to a risk? That obviously related to the law and the courts. But here we are with GDC standard 3.1.3. You should find out what your patients want to know, as well as what you think they need to know. And things patients might want to know include options, why you think a particular treatment is necessary, consequences, that word we touched on earlier, not just risks and benefits, but also consequences. Likely prognosis, whether their treatment's guaranteed, if so, how long for? What might happen if the treatment isn't carried out? And I mentioned the principles of consent 2005. So again, this predates the current GDC standards by 8 years. Find out what your patients want to know, as well as telling them what you think they need to know. So the bottom line is that Montgomery shouldn't have come as much of a surprise, because arguably, and of course the wording's slightly different, but the expectation is the same. The GDC have been requiring this of us since at least 2005, that we should be tailoring the consent process to the individual patient, asking them what they want to know, what information, rather than us making the decision for them. So in a way, the Supreme Court and the Montgomery judgment was really seen to endorse a view of consent that many thought had already prevailed, because our professional regulator was already requiring this of us. So Montgomery really could be viewed as the courts catching up with the professional regulators. So we'll talk about some practical tips. So perhaps goes without saying, but it's more important than ever to document the consent process. And records should be more than just a consent form. Interestingly, there's no requirement to ask a patient to sign a consent form from a GDC requirement perspective, unless you're carrying out treatment under sedation or general anaesthetic. It's not to say don't use consent forms. They can be helpful evidence if the consent process is ever scrutinized, but they're not an end in and of themselves, and they're certainly not a substitute for that two-way discussion, which of course is how we get consent from a patient. We have a two-way, ideally face-to-face discussion with a patient, opportunity to ask questions, cooling off period, all that kind of thing. So a signature on a consent form can be helpful as in addition to that, but they certainly are not sufficient if they're instead of that. And again, a signature on a form at the beginning of treatment shouldn't be considered as though, right, that the consent's been dealt with, I don't have to think about that again. As we've seen from the GDC standards, the expectation is that we recognize that it's an ongoing thing. It's never a fixed mark. It's an ongoing thing that we need to be consistently alive to. And of course, the consent process needs to be tailored to that individual patient, as we've talked about. And again, being careful with auto notes. Of course, auto notes can be helpful, and particularly, with computer-generated notes, if you've got a skeleton that that needs to be completed, that acts as a sort of an aid memoir to us in order to address all the different areas that we do need to these days in relation to our record keeping. They can be very helpful, of course, but if they're pre-completed, you're then a hostage to fortune as to whether or not they're going to necessarily be accurate unless you're not very carefully amending them. And certainly in my experience, when it comes to an auto note used to reflect the consent discussions with the patient, if it's exactly the same auto note used over multiple visits, it's very easy to imagine someone questioning how accurate they are. So again, discussing reasonable alternatives. As we've said, there was that judgment McCulloch last year that very helpfully clarified this point. But again, there is no requirement to discuss every possible imaginable alternative treatment in every case. And we don't need to mention the pros and cons of every option in every case. And in my opinion, when I look back at 2015 and Montgomery, when Montgomery happened, I felt like there was a little bit of a feeling amongst some people that, look, consent is this, almost, movable object that's, unachievable, and you're never going to be able to satisfy these requirements. And then the reality is that I think that that's not the case. We're all getting consent from our patients on a day-to-day basis because we're having those discussions, and we all know what the risks and benefits to discuss with patients are, both in general and specifically to a patient. And I think that actually, if we overthink this and overcomplicate it, we overcompensate. And if we overcompensate in the sense of trying to record notes that aren't accurate, we end up shooting ourselves in the foot. So I think, as I say, that there's no requirement to mention the pros and cons of every option in every case. Instead, it's about what would a reasonable person in the patient's position want to know about and consider a material risk that they should be informed of. And of course, this takes a bit of time, and I appreciate that that's easier said than done. The reality is, though, that a meaningful consent process based around a real dialogue can take more time than we might previously have considered sufficient. But of course, I think the way that we need to look at it is that time is hopefully well spent, in that it's an investment in our future time, in that if it avoids problems, which will inevitably, cost us time to deal with, then it's an investment in our future time. So I think that it's usually time well spent trying to avoid these kind of problems. Very important to focus on that individual patient, and again, tailoring the consent process to that individual patient. And is it clear from the notes that you've taken steps to do so? Have you asked? You've taken a social history. And an example that's often given is, would a chef put more significance on potential damage to a lingual nerve from a lower wisdom tooth extraction than another patient, arguably? Has the patient been given an opportunity to ask questions? Has that been documented? And again, is that an accurate note? It's not just an auto note. But again, engaging in a genuine two-way dialogue and recording both sides of the conversation, I think is really what it comes down to. And recording that accurately in our notes. But of course, we are all day to day engaging in genuine two-way dialogues with our patients. And it's simply a matter of continuing to do so, not overthinking it, and making sure that our notes are accurate. Not focusing on percentages. This was something that came out of the Montgomery judgment, that the scientific magnitude of risk is only a factor and shouldn't determine what risks are discussed. So we shouldn't focus too much on percentages that we've read in studies as to whether or not we consider this, qualifies as a risk that needs to be discussed with the patient. Considering the risk of intervening events, not just catastrophic outcomes. You remember earlier we talked about if there's a delay with the lab work, or that denture requires more than one try-in, if that patient's got a specific time frame within which they want that treatment completed, probably a good idea to make them aware of that possibility. We talked also, of course, about consequences as opposed to risks. Warning patients of post-operative pain and tenderness. Of course, we might expect that as dental professionals following many different types of treatment that we carry out. And we may not necessarily, say to us that would be expected, but of course it can have a big impact on a patient, particularly if it comes as a surprise. Disclaimers, be very careful with disclaimers, and what we mean by this is that if, let's say, a patient requests treatment that you don't really think is the right move, and you don't think it's in their best interests, and you don't think it's really going to work, but they want you to go ahead with it anyway, can you get the patient to sign a disclaimer, sort of absolving you of any sort of responsibility or consequences? The reality is that they don't stand up. The patient could still proceed to involve a third party if they want to, but a signature on a disclaimer is not going to stop them do that. And of course, they could end up damaging your defense because you're holding yourself hostage to that third party asking, well, if you didn't think this was the right move, why did you go ahead? It's your responsibility to only carry out treatment that you think is in the patient's best interest or that they're going to benefit from. So disclaimers are a risky move. So understanding, has your advice been given to the patient in a comprehensible way? Obviously, there's different ways to do it. Verbally is the big one, obviously. Documenting that bespoke discussion we've talked about. Is it clear that the patient's fully understood? Would they benefit from a cooling off period before treatment starts so that they can discuss options and the information with their family members too? Leafleting is not enough on its own. So giving patients information leaflets, again, it's not enough on its own. It's a bit like a signature on a consent form. It's not enough just to purely rely on that. It's certainly not enough just to give a patient an information leaflet and think that that's going to be enough. I don't need to have a discussion with them or ask them whether or not they have questions and all the other things we've talked about. But in my view, nonetheless, leaflets and information leaflets can be very useful. So for example, treatments like root canal treatment. If you've got an information leaflet regarding root canal treatments, all the common things that we all know can be the risks and benefits, both short and longer term, in relation to root canal treatments, that can be a helpful thing to give that patient at that initial appointment and allow them to go away and consider that information. When they then come back, giving them an opportunity to ask questions, either at that initial appointment or when they come back, going over their specific case. So obviously the information leaflet is going to have general risks and benefits regarding root canal treatment, just by way of an example, but we'd also be expected to discuss the individual case and maybe review that radiograph with the patient and discuss how those risks relate to their individual case. So you're tailoring that consent process to that individual patient, and you are looking at that patient as an individual, but the information leaflet, giving the general information about risks and benefits, takes a bit of time pressure off you, in that you're obviously giving that to the patient to take away from when they come back. You're giving them an opportunity to ask any questions. And of course, importantly, you're documenting in the notes the fact that you've given them an information leaflet. And it can be helpful to be specific about which one you've given them. Bespoke letters to patients for larger treatment plans. Certainly, some dental professionals do this. You know, obviously, there's no rules as to which treatment plans or which patients you do this for, but commonly, you know, bigger treatment plans, perhaps more expensive treatment plans that are going to, you know, take a bit of time. It's not uncommon for the dental professional to, following the consultation, send the patient a bespoke letter. And of course, inevitably, certainly in my experience, those letters will have a combination of general advice as well as specific bespoke advice about the patient's specific treatment needs and any risks and benefits in relation to their particular case. But they again can be very helpful to be sent to the patient at home by email, following a consultation, for them to consider that information before they then come back. Again, you can imagine that if the consent process is ever scrutinized or questioned by a third party, that bespoke letter can be very helpful. And of course, it's not instead of the bespoke note in the records or all the other things we've talked about, but it's a helpful adjunct to all of that. And again, a helpful way to look at this is to think about discussing treatment with your patients rather than presenting treatment to your patients. So it's a sort of a two-way decision making. Again, it's not about that the paternalistic expectations that we're going to present information to patients or present our treatment proposal to patient. Instead, we're going to have a discussion with that patient, be fully transparent about risks, benefits, what we think is relevant in their particular case, and hopefully we'll come to a decision together. And of course, it's important to make sure that you've documented how you've reached that conclusion with the patient, ideally. Okay. So, any questions? If you put them into the questions chat, I should be able to see them and read them out. If there's not any questions this evening, guys, by all means, if you do think of any and you want me to answer them, we'll be very happy to do so following the webinar. Bear with me a second, I can just see this. Bear with me a second. So here we are. Are you sure no treatment is not a reasonable option to give a patient with pulpitis, acute pulpitis? A competent patient can withhold treatment even if it leads to the acute pulpitis. And that's just one question. Yeah, I mean, I think the idea is that if you've got a patient coming in to your surgery in pain, clearly wanting treatment, clearly wanting to leave your surgery with that pain addressed, I don't think there's a requirement to give that patient, for you to explicitly give that patient the option of explicitly explain to that patient that they've got the option of no treatment. Because at the end of the day, if you don't consider that a reasonable treatment option, if you don't think it's reasonable to send that patient away from your surgery with that pulpitis untreated, which I think is fair enough, then there's no requirement for you to explain that to a patient and document it. And I also think it would go without saying that the patient understands that no treatment is an option. The fact that they've come to you for help illustrates that they're looking for help and looking for you to do something. So there's no requirement for you to say, by the way, do you realize that you have the option of not having anything done? I think that's the point. Yeah, I think that's it. I think that's the only question that's come through. So yeah, guys, if there's any other questions that come through, or that you think of any following the webinar, by all means, you can get in touch and we'll be happy to answer them. Otherwise, thank you very much for your time this evening, and I hope you found it helpful. Thank you.